Hello, good morning, good afternoon, or perhaps it's evening. My name is Herricia Willis. I'm an attorney at law practicing in Grenada for the past 6 years. As a slight background, I'm also an attorney at law in Jamaica and admitted as a solicitor of the Supreme Court of England and Wales in 2000. Well, I'm here today to inform you of wonderful news. I intend to advise and promote law in Grenada because Grenada matters.
Good evening, Herricia.
Good evening, Ingram. How are you?
I'm good. How are things with you?
Oh, I'm fine here. Lovely and warm in Grenada.
Fantastic. So, we talked about a will last time. So, this is probably part 2 of this discussion. We've talked about wills, correct?
Yes, because we spoke about when an individual, that is the testator, has made a will. Now we're going to discuss if there's no will, what occurs.
So what happens if there's no will in place? So, I guess the first question I'm going to ask you is, who can inherit if there's no will?
That one's very straightforward. There is something called rules of intestate. Most countries, well, every country has the interstate rules. That is because when a person dies without leaving a valid will, their property, which is in the legal term is called their estate, this must be shared according to certain rules. These rules are called, these are called the rules of intestate. Sorry, I sometimes cannot get my tongue round that word, intestate. Anyway, Grenada has the Grenada Interstate Estates Act. This was in 1938, but has since been amended and applies today. Well, Ingram, a person who dies without leaving a will is called an interstate person.
Oh.
Right. So when that person dies, only married and some other close relatives can inherit under those rules. So if somebody makes a will, but it is not legally valid, then these rules kick in. They decide how that person's estate, remember I said that's their property, is called estate, will be shared out. So their estate is shared out not according to their wishes, which is usually expressed in the wills. It is determined by whom inherits.
Oh, be interesting. Could that not cause confusion within a family?
No, not necessarily. In some countries, when, like, say, the brothers, the siblings can inherit, it's usually selected from those siblings who shall obtain. Well, I mentioned previously that when a person has died without leaving a will, you obtain a grant of letters of administration. So the grant of letters of administration applies to interstate persons, while a grant of probate applies when a person has left a will.
Oh
There's a
well,
will in
right.
place. Okay?
Gotcha. Got you. So, what are the rules on the distribution of an interstate estate?
Right. Remember I said to you only married and some other close relatives can inherit. And
Yes.
I also said there's an act in place, the Interstate Estates Act. Remember?
Yes.
Under that act, which is a Grenadan Act, I'm hearing talking about Grenada, there are 7 classes where persons can inherit. The first one is where the interstate leaves a husband or wife. They're married. They've left their wife or husband, but there's no children. Well, that surviving husband or wife, they've been entitled to one half of the interstate's estate. So half of it goes to the husband and wife. And the remainder half goes if the deceased has left no husband or wife. Yes?
Mhm.
So they take everything absolutely.
Okay.
But if they leave a husband and wife and no children, no, sorry, the first class is when there's no children. Now, if they leave a husband and wife and children, the husband and wife or wife will be entitled to one half absolutely, and the other half is shared equally to the children. So if there's 6 children and a husband and wife, half of that estate, say 100,000, half of that 50,000 goes to the wife or husband, and the other 50,000 is shared between the children in equal shares.
What about if the husband and wife are married, but they have no children? Like it's all stepchildren inherited from a previous marriage or previous relationship. Like I say, like the wife is from another, has had children with another man, but the man she's currently married to, she has no kids for, and
No,
it's the
well,
kids, and it's the
well,
then
well
how does that work? And it's the mother that passes away.
right. It's usually full blood and half blood. So stepchildren are not under those rules.
Ah,
It's of the
interesting.
blood.
Wanted to, yeah, I just wanted to ask about step because sometimes there's this push about stepchildren being as inheriting as well. So I wanted to
Yes.
know if they were straight in the line for that as well.
Well, it's issue.
Okay.
So in the word, I'm saying it for individuals to understand, but under the rules, instead of saying children, it says issues. So that mean it is of the husband and wife's children of the blood, rather than of
Aha.
the marriage, rather than of the marriage.
Ah, that's interesting. Okay,
Yeah,
that's interesting
it's
because
so it's the wording under the act, the issue.
I can I can see how that could get very can cause a lot of issues if the children are not even of blood or of
Correct.
of yeah, that could cause a lot of problems.
That is
Um,
why it is advisable to do a will, to have your will.
right, right.
So, so if individuals are aware of what happens or what can occur if they don't leave a will, and what will happen if they put, because the will is expressing their wishes. There's a Caribbean saying, "Oh, let them fight over it when I die."
Yes. Yes.
Not advisable, because basically that is what happens.
Okay.
Okay.
Yeah, that is something that's pretty common within Caribbean families. Said all the time. My mother said, "Oh yeah, well when I die, let them sort it out. I can't take it while I'm alive." Particularly the older members of families say that. When I die, let them deal with it. I can't deal
That
with them.
is it. It destroys the family unit when that occurs. Um, and it must be understood, when there's a death in the family, it's devastation,
Yes,
and emotions are high.
I can imagine.
Yes.
What if
Um,
there are no surviving relatives? If that's the case,
I will go on to there, but I'd like to explain the classes or the different ways that individuals can inherit,
okay.
because I've explained about if there's just husband and wife and no
Yes,
children. You know,
right.
the surviving husband and wife is entitled absolutely there.
Mhm.
Uh, if the interstate leaves a husband and wife and children, half goes to the remaining spouse, and the other half is divided equally in each. So the children have equal shares.
Right.
The third class, because it goes on, there's different variation. So if the interstate leaves children but no husband and wife, the children are entitled to the whole estate in equal shares. And if there's only one member of this class, that is the children, one child is left, he or she shall be entitled to the whole. So if the person dies and leaves only one child, of course, just like if there's a husband or wife, they'd be entitled to the whole. But if there's more than one child, they are entitled to equal shares. Okay?
Okay.
Right, the fourth class, if there's no husband, no wife, and no children, of course, then the father or the mother, or and the mother, if both of them are alive, will inherit their, because it will be the person who's died would be their child, while the parents will inherit the whole estate in equal shares. Sorry, right?
Okay.
But there's a fifth class.
Right.
If the interstate leaves no husband or wife and no children but one parent, then of course it does not go to their aunts and uncles. It just goes to that one parent who's alive. They have that absolutely. I say this because the rules in Grenada are different from the rules in the UK, in America, and in Canada. Each jurisdiction would have their own rules on inheritance when there's you have not left a will. Okay?
Okay.
Because in England actually specifies the amount of the estate, i.e., they express it in pounds. how much can be inherited. But in Grenada, it doesn't say that. It just says the whole estate in equal shares, half in equal shares. You understand? So each jurisdiction is different. So anyway, I spoke about the fifth class. If there's no husband and wife and no children and only one parent. So if the sixth one, if the interstate leaves no husband, no wife, no children or parents, there are still persons who can inherit. Okay?
The
Of
cat,
course,
the dog.
no, not us. No, they're still human beings. So if the
Okay, just check.
interstate has no wife or husband and no children, no parents, of course their brothers and sisters will inherit their estate in equal shares. Okay?
Okay.
It goes on again. If there's no brothers and sisters, then the grandparents will inherit. So if there's no brothers, no sisters, no parents, but the grandparents are still alive, then one survivor of the interstate shall take in equal shares. So if there's only one grandparent, but if there's two, it will be divided between them. And of course, if there's no brothers and sisters, no parents, no grandparents, aunts and uncles of the interstate shall be entitled.
So if it's a grandmother, how does that work?
That's way down the train. That grandmother I spoke of, because
Yes.
if there's no parents, then the grandparents will inherit. So the grandparents is in order, is before the aunts and uncles will inherit. So, yes,
Okay. Grandparents or grandchildren?
grandparents. Right?
So wait. I'm going to play real dumb here. So the grandparent, if it's a grandparent that has no will, let me get this right. The grandparent has no will.
Then it will be their children.
Right. Got that.
And then it would be, how would it go? So it'd be their parents, and then it'd be their siblings, wouldn't it? Would it not?
Right. Got it. Clear. Very clear. Very, very clear.
Got it?
Got it clear.
Right,
Just
because
want to double check.
it can be confusing.
Yeah, I want to make that clear. That I wouldn't. Yeah. Right.
All right,
Cool.
so start again. Right. So if you leave no husband, no wife, no children, no parents, first of all, your brothers and sisters will inherit. Okay? If
Right.
you've got no brothers and sisters, you've got grandparents. So you've got no other siblings. All right? You've got no parents, but their parents is alive. Your grandparents. Then your grandparents can inherit.
Right.
Then after the grandparents, it would be aunts and uncles. So it goes down and then it goes up to the grandparents. Are you there, Ingram? Cannot see you or hear you, so something has gone wrong. I did hear that you mentioned, ask a question if there are no surviving relatives. So there's a lonely soul, have no relatives on this earth, and he dies. Of course, that person's estate will pass to the crown. This is known as bona vacante. So each country's department would have a treasury solicitor who would be responsible for dealing with that estate. Under this rule, the crown can make grants from the estate, that means give out, but does not have to agree to them. Okay? What about married partners? I've mentioned right at the beginning, married partners inherit under the rules. When I say married, they have to be actually married at the time of death. So if the individual was divorced, they cannot inherit under the rules of intestates. The same with cohabitating partners, and which is commonly cohabitating is commonly referred to as common law wife or husband. No, you cannot inherit. You're not married. Under the intestate rules, you cannot inherit if you're not married. If you're living together, that's a no-no. The rules do not recognize common law status. Are you back, Ingram? Let us look at jointly owned property. What happens when a couple jointly own their home? There are two different ways of owning a home. There are joint tenancies. That's where individuals don't really know their share. They own it jointly. And there's tenancy in common, where each party knows the share that they have. A house is worth 200,000. One partner has paid in 150,000 and the other has paid in 50. That's tenants in common, unequal shares. So if the parties were joint tenants, beneficial joint tenants at the time of death, when the first partner dies, the surviving partner will automatically inherit the other partner's share of the property. However, if they held the property in what I've referred to as tenants in common, the surviving partner does not automatically inherit the other person's share. Let's have a look at bank accounts. This one's quite important. Couples have joint bank accounts, credit union accounts in Grenada. If one dies, the other partner automatically inherits the whole of the money. That is a joint bank account. They hold it jointly. Doesn't differentiate who puts the money in. You and I hold an account together, I die, you automatically inherit the whole of the money. This applies where, for instance, for example, I've opened an account and just in case of anything happens, or I put, say, a friend's name on that account. If you die, or if I die, that does not go to my family. It would go to that person whose name on that account. It does not form my estate. So a child whose parents are not married can inherit from the estate of that parent who dies. I spoke once in one of my pods about the Status of Children Act. That is mentioned there. These children can also inherit from grandparents, great grandparents who have died without leaving a will. Adopted children, including stepchildren who have been adopted by their step parents. Stepchildren who have been adopted. If they have not been adopted, they cannot inherit. So adopted children have rights to inherit under the rules of intestacy. But otherwise, you have to be a biological child to inherit. So no, a stepchildren can only inherit if they have been adopted by their step parents.
So they can't rush in between 6 months and get adopted that way and go through the process and get the adoption just to make things happen.
Well, they can't get adoption after the person's died. The adoption papers would be after death, would it not? And after you die, you don't become a person. You're no longer a person. You're a body.
What about if a member of family tries to get the step involved and to keep the money in the family, and so they get the step, they adopt the step, so that involves, so there's a legacy there, if you understand.
Yes, but the date of death is very important. Everything has to be done before the date of death.
So they can't. All right, got it. They can't do it after the event and say, "Oh yeah, well they were my step, but I've adopted them."
No, no.
I was waiting for the paperwork to go through.
No, I suppose unless you live in Grenada.
Wow. Okay. I know you think people will try fast ones all the time.
All the time. So it's a good thing you're asking this question, is it not?
Absolutely. Well, no, not that I've got anyone to adopt, but I'm just
No.
Well, I ask anyway, because
yeah. Children do not receive their inheritance immediately. They receive it when they reach the age of 18. Or if they marry under that age. That's the only way they'll get it, if they marry under the age of 18. Otherwise, they need to wait until they're 18 to get any inheritance.
okay.
All right? Other close relatives that I've not mentioned. Parents, brothers, sisters, nieces, and nephews may inherit, but this will depend on a number of circumstances. Whether there's a surviving married partner, whether there are children, grandchildren, or great grandchildren, they would come before. So I have died, then my daughter, my daughter's children, my daughter's children can inherit. In the cases of nieces and nephews, this one's a bit more difficult, because this will depend on whether the parent directly related the person who has died is also dead, because the parent of that person would inherit before their nieces and nephews.
Okay. Okay. But who can't inherit then?
Well, that's quite easy. Unmarried partners. Remember, I've said they are wrongly in law referred to as common law partners, but it's really unmarried partners. Unmarried partners, if their partner does not leave a will, they do not automatically inherit their common law partner's estate. It's the same in laws, they don't inherit. Close friends or even your carer doesn't automatically inherit. If you have a carer, you must leave something in a will for them. They do not automatically. But of course, if after listening to me, you think you um, have an opportunity or could inherit, you might be able to apply to the court for financial provisions from an estate. That is usually if you show that you're you know they support you. They always provide financial support for you.
Okay. Okay.
Any questions on that?
Not really. I think you've covered it pretty good, to be honest with you.
Yes, I thought I'd break it down to the most important points. And when individuals live together 20, 30, and I've even know 40 years, they must know that it's advisable to make a will because you do not automatically, or your partner does not automatically inherit from you because you're not married. You have to be married to automatically inherit.
Okay. What I would
And go on.
go ahead, go ahead, go ahead, go ahead, go ahead.
No, I was just going to say also, the rules are very important because individuals just think anybody can just go and inherit within a family, but no. And again, that that applies. It's jurisdictional. Every jurisdiction is different. They have their own rules of intestate.
Right, 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 right. Would you just finally just go over the key points again before you finish? Because it's a fascinating conversation you've had here with us.
Right. When you die and you don't leave a will, it does not just stop there. The law has rules on who can inherit your estate. And when you die and don't leave a will, you're known as an interstate person. If you leave a will, you're a testator. And most importantly, only married and some other close relatives can inherit under the rules. And there's, of course, rules. This is in Grenada under paragraph 4 of the Interstate Estate Act of 1938, which of course has been amended since. I think it was 1992 the rules were amended. And there's 7 different classes, and these classes sets out whether there's leaving children, no children, parent, brothers and sisters. It explains in detail who can inherit. And finally, if you have no surviving relatives, and this is under the rules as well. Finally, if you have no surviving relatives, you are the only individual left on this earth, and you die, the state, which is known in the rules as the crown, and which is also known as bona vacantia, inherits an individual's estate. Well, they don't say inherit, they say responsible for dealing with the estate. And
Wow.
of course, the Crown can make grants. Again, it's not inherit, but they can give out from that estate. But they don't have to agree to give out to anybody. They can keep the money for themselves.
Okay.
And most importantly, if you're living as common law partners, or as in the UK it says cohabitating, you cannot inherit.
Okay. Fantastic.
And I've
Now,
explained, yes, go
you
on.
explained it earlier. Now, there are people that I know watch this show, and they ask the question: can they email you?
Yes, they can. I'm happy to answer any queries. I can answer queries on the comment section, which is quite good because everybody can see the question and the answer as well. But of course, I think you have my email up. They can email me if they like. But I do like to respond on the comments section.
Okay, fantastic. And the email address is herrica@hlwillis.com.
Very straightforward.
There we go, just making sure. Okay. And in Grenada, where are you located in Grenada?
I'm located in St. George's. That's the capital. What? Sorry, I've said St. George is the capital. I'm located there.
Thank you very much for that. Herrica, once again, thank you very much for another informative, educational, and pretty enlightening conversation regarding wills, who can inherit, who can't inherit, and certainly it will change the mindsets of many who just think that they'll just leave it until they die, which I hear so many times. And
Yes,
it's not good.
no, it's not good. And as you said, this program is to educate individuals on the law. I try to break it down and not use the legal terminology so much. Well, not use, but explain the legal terminology so individuals understand the law in more detail.
Again, Herrica, thank you so much for doing this show and you're taking your time out to do the show.
Thank you very much for having me.
Hello, good morning, good afternoon, or perhaps it's evening. My name is Herricia Willis. I'm an attorney at law practicing in Grenada for the past 6 years. As a slight background, I'm also an attorney at law in Jamaica and admitted as a solicitor of the Supreme Court of England and Wales in 2000. Well, I'm here today to inform you of wonderful news. I intend to advise and promote law in Grenada because Grenada